Good afternoon to all of you on the 27th of December. We are very close to the end of 2022. Hopeful that all of you have been enjoying the relative slowdown that comes with the holidays, time with loved ones, and otherwise an opportunity to be together. To all of our friends, colleagues, and those we're thinking about throughout the parts of this country that have been devastated, though, by this recent storm and snow of tremendous impact. We're thinking of you, and just know that we recognize it hasn't been all joy for all of you, and your safety is very much in our minds. Why don't we move to the agenda, please, Kathy, and I'll walk everybody through what we intend to accomplish today. So I'll spend a few minutes going through the agenda, as we're discussing presently, as well as New York's recent bill signings and some other public health updates. Devin Karras, who is an attorney new to Bond, sits in the New York City office adjacent to my desk, is going to be speaking about proposed changes to Department of Labor's Voluntary Fiduciary Correction Program. Looking forward to learning. As always, and Devin, welcome to the program. Mara Afzali is back on the program out of our Albany office, and Mara will be covering indemnification clauses. So Mara, thank you in advance for that presentation. Delaney Knapp will be back with us, also from the Albany office, and we'll be discussing not-for-profit corporation law and some interesting technical fixes that are worth all of your attention. So thank you, Delaney. And Mario is also new to Bond and is with us from Buffalo. Thank goodness everything is okay with Mario and he's able to join us. And he'll be covering issues attendant to retention and destruction of biometric data. So with that, let's get started. I look forward to walking you through what's happening. As I mentioned, of course, we're thinking of all of you in Buffalo and in other affected communities. We know the digging out continues and there is a tremendous amount of effort underway. We thank all of the public servants and others in the emergency preparedness and response fields in particular, who are doing all they can to keep the community safe, so thank you. Why don't we move to the next slide, please? Let me quickly run through some bill activity. We are seeing the number of bills now moving in front of the governor. As we know, the end of the year deadline is upcoming. And one concerns nurse staffing hours. We're going to be watching that very closely, particularly for those of our clients who are involved in healthcare delivery. For those of you who work within long-term care, there's an interesting one concerning the program of all-inclusive care for the elderly. And then there's also one that concerns where certain postings of documents are made available. So we're tracking that as well. Next slide, please. And then bill signings are picking up. What we're seeing is an emergency preparedness package. Certainly the timing is apropos with everything we're enduring here in New York State. And there's the package there described 4 different bills that were signed into law by the governor. An environmental conservation bill that concerns statewide conservation goals. And then Carlos's law concerns injuries and fatalities concerning construction sites. That also was just signed. Next slide, please. On the federal front, a $1.7 trillion spending package is soon to be signed by President Biden. There was a brief stopgap piece of legislation signed that keeps the government running essentially through the end of this week. But the big bill, which the president is expected to sign imminently, will also keep the government running for time to come. Involves $860 billion in defense spending, nearly that much in non-defense spending. And there's also monies for the Ukraine and for natural disasters. Interesting implications for the public health emergency. And what we know about telehealth is that we've been waiting generally as far as Medicare telehealth is concerned for 151 days after the public health emergency in order to see the standards roll back to what they were before COVID. This new legislation is expected to stretch that out to a date certain, December 31st of 24. We're also going to see changes likely, again, as this is signed into law, that provide states with certitude. They can begin to disenroll individuals from Medicaid. Essentially, disenrollment has been barred as a consequence of the public health emergency, an effort to ensure that people have access to the insurance that they need in this difficult time. But it has also put strains on state programs to have that level of uncertainty. And then also we'll see the Centers for Disease Control and Prevention elevated to a position requiring Senate confirmation, that is for the directorship specifically. So next slide, please, Kathy, if you would. Also worth noting very quickly, the governor is set on her nominee for the chief judge for the New York State Court of Appeals. It's going to be Hector LaSalle. It's not a guarantee that Judge LaSalle will be confirmed. There are state Democrats who are concerned that from a policy perspective, this isn't the right pick. We'll be watching this as we move into the new year. Next slide, please. Next slide, please, Kathy. Thank you. And then we are also aware that the State Department of Health is undergoing a leadership transition. We talked about that the last time I was with you. Commissioner Bassett will be stepping down, and Dr. James McDonald will be the acting commissioner, most recently in a leadership role within the New York State Department of Health after many years working in Rhode Island. And so it's not evident whether Dr. McDonald will become the permanent commissioner. There is a search underway, but Dr. McDonald will be the interim leader. Next slide, please. And lastly, just for all of you watching the Healthcare Worker Bonus Program, we do have a bit more information concerning when payments will be issued. For those of you as employers who were involved in vesting period 2 submissions, look for them through Medicaid billing, or rather Medicaid reimbursements through cycle 2366. This may not apply to all of you, of course, if they're educational providers and others who will receive the reimbursements through other avenues, but we just wanted to make sure that for those of you in the Medicaid system, you have this additional piece of information. And why don't we move to our next speaker then, please, Kathy? It's Devin Karras, whom I mentioned earlier, and Devin comes to us from the New York City office by way of Michigan State University, as well as where he did his legal studies, and then at the University of Michigan before that for undergrad. And he's a very skilled attorney in benefits practice, including health and welfare plans, and generally is here to tell us about an update in the benefits world that all of us should take heed of. We're glad to have you with us, Devin, and looking forward to learning, and very much welcome you to this program.
Thanks, Gabe. Yeah, thanks, Gabe. Thanks for that introduction. Hi, everyone. As Gabe said, my name is Devin Karras. I'm Senior Counsel in Schoeneck King's Employee Benefits and Executive Comp Group. Hope you all had a relaxing weekend. For those of you up in Buffalo and others affected by the winter cyclone bomb, as Gabe said, we are also thinking of you and hope you and your loved ones are doing okay. From the jump, I just want to inform all of you that Secure Act 2.0 is part of the $1.7 trillion omnibus bill that was passed last week due to be signed imminently by President Biden. Please note that the Secure Act 2.0 has important implications in the employee benefit space. And I know that either myself or someone from my group will be discussing this at another one of our events in the coming days. So please stay tuned. Secure Act 2.0 is very important and substantive. But so that said, What I'm here to talk about today is just speak briefly about some proposed changes to the Department of Labor's Voluntary Fiduciary Correction Program, or VFCP. And these changes were published in the November 21 edition of the Federal Register. Some quick background and refresher: the VFCP program is intended to encourage the identification and correction of certain fiduciary transactions that violate or may violate ERISA and result in a penalty or civil liability under ERISA sections 502L regarding breaches of fiduciary duty and section 502I concerning prohibited transactions under ERISA. VFCP, as it currently stands, it allows for the correction of 19 specific fiduciary breaches. For example, prohibited purchases, improper loans, improper plan expenses, and I think probably the most prevalent sort of fiduciary breach that's corrected through VFCP is correction of delinquent participant contributions and loan repayments. VFCP is a program that provides for plan practitioners an acceptable means of correction that the DOL will bless if these breaches are corrected in accordance with their procedures. So again, if a plan official corrects one of these 19 identified breaches in accordance with the VFCP, the DOL will issue a no action letter regarding the correction, the effect of which is that the DOL will not initiate a civil investigation regarding the breach nor assess civil penalties under sections 502L or 502I, as I just cited a couple seconds ago. The important thing is, though, is that, or as some of us probably know, that fiduciary corrections through VFCP can be time consuming, and they require, among other things, a formal application to be submitted to the plan's regional DOL office, requiring a detailed narrative of the breach and explanation of the breach, including how it occurred, how it was corrected, and by whom, and when, and as applicable, a description of the calculation of any lost earnings, interest, or profits that relate to the breach. And all of this has to be accompanied by supporting documentation proving that the breach was corrected. I note again that the most common fiduciary breach that's corrected through VFCP is the failure to remit participant contributions to a plan timely or remit plan repayments to a loan. This typically occurs at like on the payroll level, and it can be sort of a recurring knitting pain in the butt issue, but that's what VFCP is for. And the DOL has basically suggested that it doesn't matter how minor the failure to remit is, they still want to see VFCP corrections made for late remittances or repayments. And I think the DOL is cognizant of the fact that plan practitioners and are very annoyed by having to make those corrections. That can be a real pain. So in light of sort of the groaning and the clothes rendering by plan practitioners about having to correct through VFCP for such minor mistakes, the DOL concluded that certain revisions to the VFCP program would be probably worth their time and would facilitate use of the program by plan practitioners and plan sponsors. So they're trying to encourage program utilization. So it's also worth noting that the VFCP program hasn't been revised since 2006, when the VFCP's IRS counterpart for the correction of plan errors, EPCRS, the Employee Plans Correction Review System, under the IRS correction program, that's been revised multiple times in the last decade. So the DOL has been very much behind the ball on that, trying to stay sort of on par with the IRS. So in light of all these things, the DOL finally realized that some changes were due and looks to be paying more attention to plan compliance and correction. In other words, the DOL is basically starting to step up their game, so to speak, when it comes to plan corrections. So what's the big news? If you want to go to the first slide, Kathy. So the big news, there's possibly big news depending on your perspective. There's a proposed change to the program. It's the addition of, there's a proposed change to the VFCP, and the proposed change is the addition of a new self-correction feature applicable to a plan's failure to timely transmit participant contributions and loan repayments to tax qualified plans. So if there's a late remittance or a late loan repayment on the part of the employer, big news, you can self-correct as proposed. We're still in the proposal stage. So the new proposed VFCP self-correction method is, at this stage, it's being called the self-correction component, or SCC. Relief under SCC, if the proposed changes are adopted without subsequent revisions, will be available for delinquent contributions and loan repayments to any pension plan, regardless of size or plan asset amount, if the lost earnings associated with delinquency is $1,000 or less, and the contributions or loan repayments are remitted within the last 180 calendar days from the date of the withholding or receipt. In this case, the date of breach. Just to note, the DOL has indicated that they were initially looking at sort of like a time limitation where you have, if a plan is being corrected through SCC so many times within, say, 3 years, they would limit that. But rather than limit the number of SCC corrections you can make, they just basically indicated that they will be monitoring a plan's frequent use of SCC and consider opening investigations to identify and correct systemic issues and identify repeat offenders in the event that there's constant corrections through SCC, so those could be addressed. Importantly, to correct, Kathy, next slide, please. So to correct a delinquent contribution or loan repayment, an SCC correction must include both a remittance of the principal amount and any lost earnings attributable to the principal amount. You're probably, many of you, aware that the principal amount is the amount of the contribution or loan repayment that would have been made to the plan had there not been a late remittance or repayment. That's just the same definition as it is under the current VFCP regime. Same thing with lost earnings. Lost earnings are the amount of earnings that would have accrued on the principal amount, but for the breach. This is an important distinction that's following up. So the SEC is going to require that the lost earnings be calculated as the, quote, date of withholding or receipt, and require the use of the VFCP's online calculator to determine the amount of the loss payable to the plan. Now, for purposes of the correction through SCC, the date of the withholding or receipt is the date that the principal amount would have otherwise been withheld or payable to the participant in cash in the amount of participants with respect to participants' wages, or the day that the participant contribution or loan repayment is received by the employer to be reported on to the plan for a loan repayment. So the use of the date of the withholding or receipt, it's a metric that's stricter than what exists currently under the VFCP program. In that case, under the current VFCP program for non-SCC corrections, lost earnings is determined from the date the remittance or loan repayment should have reasonably been made to the plan. So there's a little bit more wiggle room as to determining what the date of loss is by looking at when the remittance could have reasonably made to the plan versus the actual date under SCC, the actual date that the payment is made through the payroll processing to the participant. In addition, Kathy, next slide, please. So in addition, the SCC program is going to require the plan operator making the correction to use the VFCP calculator that's online and available to everybody currently. And it's also going to require the plan official. Next slide, I apologize. The SEC is going to require the plan official correcting the breach to file an electronic notice with the Department of Labor, and that's going to be replacing the paper form currently in place under the VFCP program. Again, that's good news. Things are getting streamlined under the SEC program. The electronic notice probably isn't going to be different than or vary considerably from the current VFCP filing, but it is going to require that the plan official include certain identifying information. No surprise, the plan name, the principal amount, the amount of loss earnings, the date of the loss, i.e. the date of the withholding or receipt, and other things like the number of affected participants. Also new to the VFCP program through SCC is that self-correctors are going to be required to complete an SCC retention record checklist, which is going to be part of a new Appendix F as part of the amended VFCP program. And they're also, going to be required, the self-corrector is going to be required to prepare and provide the checklist to the plan administrator for records retention purposes, as well as complete a penalty of perjury statement. That's, again, it's in boilerplate language through the new proposed Appendix F. So a lot of this is being done as I said from jump, that to streamline the process, there's boilerplate language that the DOL is going to be providing to plan correctors through SCC. So again, that's very good news. Worth noting, however, that correction under SCC is not going to result in a no action letter. This is an informal sort of submission. So there will be no formal no action letter from the DOL as would be issued under the conventional VFCP submission. But all indications to date are that the DOL has stated that compliance with the proposed SCC program will result in the submitter not being subject to civil monetary penalties or an EBSA civil enforcement action, provided that the correction is verified by the DOL. Also worth note, because this is proposed, these are proposed changes, the new SCC element to VFCP is not going to be implemented until the changes are approved after written notice and comment, and the program is ultimately checked off by the Office of Management and Budget. But written comments are being accepted by the Department of Labor up until January 20th of 2023, which is right around the corner. So until the finalization of these proposed changes come through, the current VFCP corrections are controlling. And also worth noting, as I said from the top, that the DOL is looking to facilitate and streamline their VFCP program. They're also taking, the DOL is also taking comments on other, I suppose, improvements to VFCP. Among them, they're taking comments on perhaps making all of VFCP, not just SCC, an electronically filed correction program. They're also thinking about taking suggestions from plan practitioners and sponsors and other experts about whether the DOL's VFCP program should be or could be more fully harmonized with the IRS's correction program through EPCRS. And they're also going to be looking to receive comments about including a new, I suppose, 20th fiduciary correction that can be corrected, or fiduciary breach that can be corrected through VFCP. That relates to locating missing participants. That's been a very sensitive topic for the DOL for the last 4 or 5 years. And they're coming down hard on a lot of plan sponsors and plan administrators who are failing to distribute amounts to plan participants who they can't locate. So they're basically considering that a fiduciary breach. And if you get dinged on a DOL investigation, they're looking to see if VFCP correction through for failure to locate missing participants or implement a policy or program can be fixed through VFCP. So the DOL looks to be very much active on VFCP and plan compliance and correction. It seems to me it's about time. However, when these things happen, it's just more headaches for a lot of people. But ultimately, it's in the interest of plan participants and beneficiaries that plans be operating efficiently and correctly. So even though it may be headaches for plan administrators and sponsors, ultimately this is it's good for plan participants. So that is my summary on the new proposed corrections to VFCP. That's it for me. So I'll be signing off and pass it along to Gabe as the MC, but I'll be standing by to answer any questions if anyone has any.
Devin, thank you so much. Really appreciate the coverage of the VFCP. And if there are questions, please feel free to answer them through the chat. I'll now introduce our next speaker, who's Mara Afzali, who's back on the program. Mara is with us from our Albany office, and Mara will be discussing indemnification issues. A bit of background on Mara, if you weren't otherwise familiar, includes that Mara, in addition to being an attorney at Bond, also serves as a captain in the United States Army Reserves within the Judge Advocate General Corps. So plenty to talk about outside of Mara's presentation topic, but please trust you are in good hands with Mara, and there's a lot to learn. So Mara, the floor is yours.
Thank you, Gabe. Thanks for having me. I'm happy to be here today and have the opportunity to give you a brief update really on a contract law interpretation issue that recently the Court of Appeals, the highest court in New York State, has recently taken up. And just to make sure that you all are aware of this change, because it may impact the prevailing party or entity in a litigation matter from the ability to recover attorney's fees and other costs based on the language in your contract. So next slide. So first of all, a quick reminder or overview of what an indemnification clause is. So these are, you'll see this language in pretty much every contract, commercial agreements, often commercial leases and other types of contracts, which essentially outlines the parties' intentions regarding risk allocation should there be a litigation that arises. And because of that, obviously, litigation costs are a huge factor in determining whether or not to file a lawsuit or how you defend and the strategies around defending a lawsuit. And so they're a heavily negotiated provision. And typically you're looking at the obligation to defend the other party and or to reimburse costs and fees, which very notably and very often includes a negotiation around the shifting the ability to recover attorney's fees. So next slide. And why is it important specifically is that in New York, as a general rule, we follow what's called the American rule, which means that without any language otherwise, so as a default, whether there's language in a statutory or a contractual basis, absent such language, you can't get those fees. So unless you put that language into the contract or unless there's a separate statutory basis for awarding it, you can't get attorney's fees. And New York courts tend to, as a general rule, narrowly construe any indemnity obligations because we want to make sure that parties are expressly agreeing to that and that it's clear that that was part of the agreement. Next slide. So one distinction right here, there's the direct versus third party claims. So you may have both one or the other typically included or addressed in an indemnification clause. So the claims that involve a third party would be the two contracting parties, party A and party B, enter into a contract, and some sort of dispute arises with a third party, party C, some type of dispute over a subcontract or over something related to that contract. And party A and party B include in their agreement that should those third party litigation actions arise, one or the other party has the obligation to pay for attorney's fees and costs of defending that action. Then there's also a direct claim, or what we also call an intra-party indemnification, which addresses the fee shifting or who's going to cover those costs should a dispute arise between the parties on the contract. So one party raises the issue regarding a breach of that agreement, and so those would cover the fees of the other party in defending against that. So that's what we'll call a direct or intra-party indemnification. And that's really what we're getting at in this recent development in the law. So even though New York has traditionally, and still continues, I'll say, to follow the American rule, the trend had been in the New York court systems to interpret any broadly worded indemnification clause to include intra-party indemnification. So they would consider such a broad agreement to expressly include both direct and third-party claims in that recovery. Let's move to the next slide and you can see an example of this. So the case at issue here was just decided in October. And the issue there was a partnership agreement between the two parties and a dispute had arisen over the dissolution of that partnership. And the prevailing party, so the party who's winning, wanted to recover their attorney's fees and believed that the language in their agreement allowed them to do so. And so you can see the language there, and I've highlighted some of that broad language we're talking about. And it says against any and all claims, demands, liabilities, costs, and damages of any nature whatsoever. So this is that broad language that historically courts had considered to be an express agreement to include the recovery of attorney's fees, both in a third party and direct action. And that's what the court had originally decided, that this did include the ability of recovery, and they awarded that to the prevailing party. And they appealed that decision. It went up to the Court of Appeals. And the Court of Appeals disagreed. And that's what's really notable here. So it's not really a change in the law, but a clarification from the court, the highest court, that this is not enough. This is not enough language in the court's mind to meet the American rule or the New York rule in terms of being broad enough to make it clear that the parties meant for the recovery of fees and expenses for both third party and direct actions. And so instead, what they decided, they reversed and they said that the party could not recover that fees because there was nothing in this provision that made it unmistakably clear that the parties intended to permit recovery on an action between the parties on the contract, i.e. direct fees, a direct claim. So next slide. That's really the takeaway here. The takeaway is that we want to be looking for both forwardly, we want to be looking at, as you're entering into a contract, are you making it unmistakably clear that you intend to include the recovery of fees in both contexts? You can use the language, make it very, very clear that you're covering both third party and direct claims, if that's what you want. If it's not what you want, make sure that it's laid out very expressly in the contract language. And then notably as well, you want to make sure that you're going back or you're having your attorneys look backwards at any agreements you may have entered to in the past that you believed or the parties believed made it unmistakably clear that you intended to include direct claims, recovery of attorney's fees in direct claims. But maybe now a court would no longer interpret it as much. So the parties in the case at issue here, right, reasonably under the law as it existed at the time they drafted that contract would have believed perhaps that it would cover both direct and third party claims. And now in those contracts, you're going to want to go back and make sure to look at that language and either renegotiate a contract amendment or somehow otherwise address that issue in those prior contracts and certainly moving forward. So Gabe, that's really my update here in terms of this new case. It seems like maybe a small thing. It's really technically not even a change in the law as much as it is some clear guidance that we need to be careful moving forward in dealing with this issue.
That's terrific. Thank you so much, Mara, for bringing this group up to speed and for ensuring that there is this awareness around these issues in indemnification structuring. And let me pass the baton to our next speaker. And if anyone, of course, has questions for Mara, please enter them in the Q&A function. But we are pleased to have another attorney from our Albany office with us. Delaney Knapp is back. And Delaney, thank you for taking the time to walk us through not-for-profit corporation law and some new technical fixes that are a consequence of this recent legislative session and bill signing by the governor. Delaney, please walk us through. Thank you, as always, for being with us.
Yeah, thanks for having me. So, unlike Mara, my presentation has to do with actual changes in the law. So if you can go to the next slide, Kathy. In late November, the governor signed legislation, and the intent of this legislation was to update the not-for-profit corporation law to align with some more modern practices of nonprofits to help streamline their governance procedures and eliminate any unnecessary regulatory burdens. And this was part of a greater effort to provide nonprofits with greater clarity and comfort in interpreting some of the more ambiguous provisions of the law. And so the groups who've been pushing forward some of these, what we're calling technical fixes, are really trying to listen to the experiences of their clients, are witnessing how the law is taking place, practically speaking, in terms of governance, and then going back and advocating to the legislature to update the law so that it more accurately reflects what it's like to operate a nonprofit in the modern day. Next slide, Kathy. So there's 3 changes that I'm going to talk about. None of these are earth-shattering. Honestly, some of your organizations may already be implementing them and may not have known that they weren't compliant with the law at the time because of this ambiguity. So the first one is that with respect to voting or approving action of a board, we know that unanimous written consent is allowed, and typically the language had included it needed to be in some form of writing, and there was explicit authorization of using email or electronic mail. So this has now been expanded to allow any electronic means, that's the term. And it's really meant to contemplate the use of electronic portals, which are being used by organizations to collect votes, which can be a more efficient method than collecting votes by email. And this is, a change really meant to just update to modern practices. We know many organizations are doing this, and so it makes sense that the law reflect what's happening so that those organizations are compliant. Next slide. So the second one is with respect to when you have a director who, resigns from the board and you have a vacancy on your board. Typically, organizations would elect someone to fill that vacancy. And what seems most intuitive is that that person would fill the remainder of the term for that director. So if it was a 3-year term total, they resigned after 1 year, the person you reelected would fill out the remainder of that 3-year term. They would serve the next 2 years. And that there was some ambiguity about whether or not that was actually allowed. Technically, they should have only filled that vacancy until the next annual meeting and then been reelected. But that was leading to some confusion and a lack of clarity as to whether boards were validly constituted. So this has been changed so that a director who is elected to fill a vacancy can be filled for the remainder of the expired term or for a different period of time as determined by the board. Next slide, Kathy. And this is the last one. And this is really just to clarify the idea that sometimes board members or committee members have to recuse themselves from meetings due to a conflict of interest or their involvement in a related party transaction. And that recusal is not going to disturb the quorum that needs to take place and be present in order to take any form of board action. And so one thing that would be helpful, and what I've seen in some bylaws, and you may want to check your bylaws to see if this is in there, is that I've seen language stating that as long as a quorum is present at the beginning of a meeting, so it doesn't matter if it is disturbed later on or if people leave, as long as it's there in the beginning, then a vote can happen. And that's not the case. A quorum needs to be present at the time of the vote, absent any directors who are recused for a conflict of interest. So if that's something that's in your bylaws, you might want to check and have those updated. And I guess my plug here is if you would like any of these changes added into your bylaws, if you need a bylaw review or any of your other corporate policies, we'd be more than happy to do so. Next slide.
Thank you so much for being with us. And we appreciate this update. It really makes a difference to have that kind of quick yet topical background provided. So Delaney, you're always welcome back on the program, and we appreciate the time you've taken today. And let me now introduce our final speaker, who is Mario Ayub. As I mentioned, Mario is with us from Buffalo. He also is someone who recently joined Bond. He had undergraduate training at SUNY Buffalo. He has a master's in public policy from Duke, as well as a law degree from the University of North Carolina, and is part of our cyber and data privacy team, and is here to tell us about some interesting developments in the law out of Illinois that will be worth your time. So please, everyone, take a listen. And Mario, thank you for being with us, particularly under the somewhat trying circumstances you and the Buffalo community are enduring.
Thank you, Gabe, for having me on today. The plows just made it down my street a couple hours ago, so I get to leave the house today, which is pretty good. But I hope everybody's safe and warm and had a good holiday break. So thanks for bearing with us to the end here. I will make this as interesting as I can. So I'm going to talk a little bit about retention and destruction policies, particularly in the context of biometric data. And this involves an update, a rather significant update from the Illinois courts involving BIPA, the Biometric Information Privacy Act, and the requirements for covered entities and private citizens. So if you could go to the next slide, please. So before we get into the case, I just wanted to give a brief overview of BIPA for those who are not familiar with the act. So it was enacted in 2008. It's been around for a while. It's one of the first of its kind. to have a comprehensive approach to regulating the data lifecycle from collection, retention, disclosure, and deletion, with specific requirements for each stage. We're going to focus on the retention and deletion aspect today, but I just wanted to give you a broad understanding. And why do we care about a decision out of the Illinois court on an Illinois statute? That's because this statute can apply quite broadly to any private entity, any covered entity. There are a few exceptions, limited exceptions, that collect biometric data from Illinois residents. And the Illinois resident does not necessarily have to be within the state at the time of collection for this collection to fall under the purview of BIPA. So it's quite flexible. It applies to many businesses in New York and in other areas outside of Illinois. So it's worth paying attention to. I wanted to identify two definitions that were included because I think it's important to frame the scope of this law. So the first definition they provide is biometric identifier. And this is exactly what you might think when you think about biometric information. So the actual scan of the physical characteristics. So you have an iris scan, a fingerprint, a voice print, the actual imagery. And then they provide another definition, biometric information, which is a much broader catch-all provision. That means any information, regardless of how it was captured, regardless of the format, that's based on that identifier. So a common example of this would be if you use your face to unlock your iPhone, your phone doesn't store the actual map of your face. It is converted to a token, and that token is checked every time that you scan your face. That token will be considered biometric information, even if it's a series of numbers. That still falls within this Act's purview. So I just wanted to give you guys a sense of how broad this really is and how it can apply to New York businesses and other businesses outside of Illinois. Next slide, please. So for today's discussion, I want to focus on just the one requirement that was at issue here in the case that we will get to in a moment. So a private entity in possession of biometric information has to develop a written policy, make it publicly available. And this policy has to establish a retention schedule and guidelines for permanently destroying biometric information. As soon as the initial purpose for collection has expired, or that purpose is complete, or within 3 years of the individual's last interaction with the entity, whichever occurs first. A couple things to note here is the publicly available requirement. This is easily satisfied by either putting this into a existing privacy policy, adding a link to your web page, with a separate statement, just laying out this schedule. It's flexible on how you want to do it. It just needs to be easy to find and contain the schedule and walk through the process of deleting this data when there's no longer a need for it. So that's what we're going to focus on today for this case. And if you could please move to the next slide. So Mora and J&M Plating, it's an Illinois state case. The plaintiff brought the action in 2021. Here's a little background of the facts leading up to the dispute. So in 2024, the defendant, J&M Plating, a manufacturing company, began collecting, retaining fingerprints for use with their time clock system. It's fairly common. A lot of businesses use this. You just, instead of punching in an employee identification number, you just scan your fingerprint and you can punch in and punch out quite easily. 4 years later, after they've started collecting information from their employees, J&M Plating then developed and published, made publicly available, this destruction policy in line with BIPA. It contained all the proper components that you'd need, but it did come 4 years after the collection. And mind you, now 10 years after BIPA was enacted and became effective. So it might be a little too late. 2021, Mora's employment was terminated, but his biometric data was destroyed in line with the policy, in line with BIPA, no issues there. So those are our facts. And if you can skip to the next slide, please. So Mora commences a class action suit a couple months after termination. And basically he argued that the BIPA was violated because his employer did not release these policies until 4 years later, until after his information was already in their possession, it was already being used for timekeeping purposes. And J&M Plating moved for summary judgment. They wanted to dismiss the suit because BIPA does not contain any timing language. We looked at the language just a few slides before. There isn't any mandate for a specific time frame or a deadline to have these policies in place. And then the other thing that they argued, which is also interesting, is Mora wasn't harmed here. There wasn't any unauthorized access or disclosure of his data. It didn't fall into the wrong hands. They deleted it in line with the policy. No harm, no foul. The trial court agreed with the defendant here, J&M Plating, but the appellate court later reversed. in the next slide, we'll discuss a little bit of the court's reasoning there. So in deciding that there was a BIPA violation here, the court stated that, quote, the explicit trigger for the development of the written policy, meaning the retention and destruction policy here, is the private entity's possession of biometric data. So the obligation really triggers on possession. Of course, it's going to be very hard to develop a policy within a few hours of collecting this data and having this ready to go. So ideally, it has to come before collection. This policy has to be created and publicly available before collection. And publishing policies post-collection is inconsistent with the Act's, quote, preventative and deterrent purposes. A lot of the Act is geared toward giving consumers, giving individuals or employees adequate notice of what their data is going to be used for, where it's going to be stored, how long it's going to be stored for, and because it's such sensitive data with physical characteristics unique to the person, you need to know how they're going to erase this data, and if that's going to be sufficient to comply with other data privacy laws that require proper deletion. So if you're posting a policy after the fact, the individual or the employee cannot make informed consent because they don't have all the information ahead of them. So the court reasoned that this retroactive adoption kind of flew in the face of the Act's purposes. And of course, it imposes a strict timing requirement that we've never seen before with BIPA litigation for the adoption and retention of deletion schedules. If you're going to slip to the next slide, please. So some key takeaways. It's interesting because it's bad news for businesses and those who are collecting information, and good news for those bringing suits. This pretty much establishes a strict liability standard. And the court here was not concerned whether Mora was actually harmed, whether the plaintiff was actually harmed by the company's failure to publish these policies. So the litigant doesn't have to have a showing of harm. They just have to point to the fact that the business or their employer did not have this policy in place prior to collection, and that's going to be enough to get your case in the door. So ideally, again, schedules should be in place prior to collection. And the third bullet here, it might seem a little out of place, but it's in relation to what the definitions that I was talking about earlier, determining whether your business needs to comply with BIPA at all. And it's not necessarily obvious all the time what information will fall under purview of the Act. So when assessing this, when assessing your data collection and speaking with the folks at your organization that are responsible for this effort, be sure to use examples of biometric data. So it doesn't necessarily have to be the image. It could be an identifier based on the image. Use examples and try to tease out that information to make sure that you don't need to comply with BIPA. And finally, and most obviously, keep careful records of your policy adoption. Establish a clear paper trail so that if you are faced with one of these types of litigations where the bar is low and there doesn't have to be harm, you can quickly point to a well-documented process for having these policies in place. Bond helps our clients all the time getting these policies in place and updating them as the laws change. So if you have any questions regarding compliance with BIPA or developing these policies, feel free to use the contact information included in the packet, and I'll be happy to talk with you further. And now I'll send it back to Gabe.
Mario, thank you. That was really informative. We received several questions in the chat, and unfortunately, we're not going to have time to attend to them now, but Mario, I trust that you'll be in touch with those who post them in follow-up. What I do want to, though, share is our excitement and our enthusiasm for the year ahead. 2022 is coming to a close, of course, momentarily, but we will be with you at Bond to bring business in 23 to you, starting with our first program in January. It has been an honor to be your host for a good chunk of this 22, and I look forward to providing guidance in 23 programs to come. An important programming note, we intend to have a 2022 year in review. And we had mentioned in the program last week that it was going to be on the 3rd. For scheduling reasons, we will have it instead on the 10th. We will have regular programming on the 3rd, so please do tune in. And we're wishing all of you a very joyous, happy, safe, and healthy new year. And we will be with you in 2023. For the moment, please just have the best holiday season you can. and know that the bond team is here for you. Have a good afternoon.